Justice Kavanaugh?
I want to follow up on Justice Gorsuch's and Justice Kagan's questions with how the major questions doctrine applies, and really first zero in on this question of ambiguity. We've used words like vague, subtle, oblique, cryptic, and ambiguous to describe the kind of language that would trigger the major questions doctrine if it is a major question. We haven't only used the word ambiguous. And it seems to me that a question that I'd like your help on is applying language that is subtle, cryptic, oblique to a new context hasn't been done before in the last 50 years. How do we think about a question like that? And in answering that, think about the benzene case, the Brown and Williamson case with tobacco, benzene with cancer, and the UARG case with greenhouse gas emissions. All three where the agency was applying this broad but arguably cryptic language to a new context. I think that's one way to characterize them. How do we think about that?
Well, I think Justice Kavanaugh, looking at those three cases in particular, that the reason the court concluded that the language was cryptic or oblique was because it identified other textual or structural reasons that ran counter to the agency's interpretation. So in the utility air case that you referenced, the court observed that the asserted regulation would overthrow the entire statutory scheme. The agency had conceded that it was never what Congress could have possibly intended. So that was a structural indication that the agency's regulation was impermissible. With respect to the benzene case, there too, there was a question about whether there was an entitlement to regulate without any finding of risk, and that was in tension with other statutory provisions, so there was a conflict. And with the Brown and Williamson case that you mentioned, the court chronicled a long line of statutes that had directly addressed the issue of regulation of tobacco products and would have been flatly inconsistent with the agency's asserted jurisdiction. So there's never been a case where the court has just confronted broad language and said, oh, it seems cryptic or oblique, and so it's a major question, and we're not going to give it its plain meaning. In all of those cases, there was a textual and structural reason for the court to conclude that there was something wrong with the agency's claimed authority.
In all three cases, there were strong dissents that said the opposite of that, though, that said actually this statutory language is clear, and that the court, Justice Marshall's dissent in the benzene case is very powerful, that the court was simply scaling back from the plain language because of its concern about the significance of regulating every workplace in America to take out any risk of cancer. So there were dissents that made that point, but the majority seemed nonetheless to apply the major questions doctrine.
There were certainly dissents in those cases that thought that the statutory terms could get the agency there. But here I think the critical difference is that the applicants haven't pointed to anything in this statute that approximates the kind of textual or structural problem that has prompted the court to look at those kinds of consequences before. And it would be their interpretation that creates those problems. They would render superfluous Section 669A5's specific recognition that immunization requirements can be imposed under the OSHA Act itself. By saying that OSHA can't regulate COVID-19 in the workplace, they'd give no effect to Congress's appropriation just last year directing OSHA to do just that and to target that grave danger. And so in this case, we think that all of the textual clues line up on our side in addition to the plain language of the statute.
Then one other question related to this, sorry to prolong this, but Congress has specifically referred to vaccines in a variety of contexts. Immigration contexts, those statutes authorized specifically by language vaccines. Military contexts, which you would expect, at least the anthrax vaccine is referenced in the military statutes. The National Childhood Vaccine Act, passed in '86, refers, and that's a different context, but dealing with vaccines. And so that's one point. And the other is, since it forever, but 2005, President Bush gave a very detailed speech kind of predicting what has happened. And it's eerie to read it. And yet, in the years since, there has not been at least a vaccine statute passed by Congress to deal with this kind of thing, even though he, in the wake of 9/11, but still was putting the country on notice of this problem that was going to hit us at some point.
Well, I certainly recognize that there are other statutes where Congress has specifically referred to vaccination, and I think that maybe that would get the applicants some traction here if, for example, this act specifically referred to other mitigation measures and illuminated what kinds of things OSHA could do and left vaccination off the list. But it doesn't do that, and so I think to suggest that there is some negative inference to be drawn is inconsistent with how Congress drafted this statute and recognition that OSHA would be positioned to understand the kinds of control measures that are necessary against the variety of workplace hazards. And if I could just make one additional point on that, of course, as I've emphasized, there is an express reference to immunization requirements in the OSHA Act itself, so we think that that actually provides additional confirmation that Congress was thinking about that and could have anticipated it, and that religious exemption would have no application if, in fact, immunization is just off limits. But I think, as well, it's important to look at this against the backdrop of immunization requirements in our country. This is not some kind of newfangled thing. As I've mentioned before, most of us have been subject to compulsory vaccination requirements at various points throughout our lifetime. And so the idea that Congress couldn't have anticipated that in dealing with the deadliest virus that OSHA has experienced in its history, it might think that vaccination, encouragement of vaccination, would be an appropriate way to protect workers, I think is just inconsistent with the idea that vaccination is often the single most effective way to target a virus.
Thank you.
Justice